hunters for deer versus the town of Smithtown. Counsel?
Good afternoon, Chief Judge and Associate Judges. May it please the Court, my name is Jennifer Youngst. I'm an Assistant Town Attorney from the town of Smithtown, representing the appellant in this matter. I'd ask to reserve 4 minutes on the rebuttal.
4 minutes?
Correct.
You may.
The town's here to ask this Court to reverse the appellate division on its decision from August of 2020. The issue presented here is whether or not the state occupies entirely the fields of defining what a firearm is, as well as setbacks. Our position is that a number of issues were made in error in the appellate division's decision.
Counsel?
Yes.
Counsel? Sorry, here. Is the town's position, and I just want to understand this, is it that you have the authority to do this under the Town Law 13027, which you've defined firearm to include bows and arrows, or is it that, or both, that you have this residual home rule authority to do this?
Both, Your Honor, in addition to New York's
So
Constitution.
why would you need 13027 if you have home rule authority? Why would the legislature pass it?
I'm not certain how to answer that, Judge, why the legislature chose all the way back in 1966 to make that a new addition.
You know, you make me feel very old. But so,
Sorry.
but let's say, but there has to be a reason for it, and if the towns, the localities under specific circumstances have the authority to do this already under home rule, why do you need the town law?
The town needed to clarify that given the density of the suburban area of Smithtown, and as it grew since the 60s.
No, I understand why you would want to do it, and the policy reasons for doing it. I just don't understand why the legislature would need to pass the town law if you already had the home rule authority to do it.
Your Honor, I really don't have an answer to why the state legislature decided to enumerate that at this point, but certainly the town of Smithtown felt it necessary to include it in its town code.
Let me ask you this then. Is it your view that under the home rule provision, you could go below 150?
Under the home rule provision,
Like, so if you wanted, if Smithtown decided, look, we have a real deer problem here, let's go to 100 feet for bows and arrows.
well, first of all, I don't think the town board would want to.
No, but forget it. This is hypothetical. I don't think your town board would do that either, but hypothetically, could you do it?
Yes, we believe that we could set it where we wanted to, as long as it was more restrictive, so we couldn't go lower.
So that was, I'm sorry, that wasn't clear.
that-
That was my question. Could you go lower? I think I'm doing it
No,
right.
we wouldn't, we could only increase by remaining above to be in a safer zone, is what we
Okay.
consider it.
Thank you.
Okay. We believe that the appellate division did not make a conscious effort to consider the differences between the two laws that are before you now, the Environmental Conservation Law 11-0931 and Town Code Chapter 160, together with the State Town Law 130. They're two very different types of law. The ECL provisions are crafted and intended for killing deer as part of the state's management of wildlife, while the town code, together with town law, is intended to protect human life. So with those vastly different purposes, we believe that this court will find that there's room to look a little bit deeper than the appellate division did.
Counsel, it seems to me that if you look at the history of the amendment to the ECL, questions of public safety were taken into account when they made the determination, rightly or wrongly, to reduce from 500 to 150. So I don't think you can argue that this is strictly about killing deer. There at least seems to be some consideration of what a reasonable public safety limit would be, arguably on a statewide basis. You don't agree with that?
We don't, Judge. We believe if you look at ECL in a wholesale version, together with the specific policy statement in the declaration, is solely about controlling, and rightly so, fulfilling the entire, taking up the entire field of wildlife management across the state. However, deers don't exist uniformly throughout the state, and that's one of the
But
reasons.
can we just get back to people?
Sure.
Because I seem to recall a portion of the legislative history with respect to the amendment, talking about how they had come to a conclusion that firing a longbow, or, shooting a longbow, you could expect the arrow to fall to the ground at about 150 feet, as opposed to their prior longer length. That doesn't sound to me like a concern attendant upon killing deer. That sounds like a concern related to whether or not people are going to get hurt if you set the setback at 150 feet.
Respectfully, Judge, we didn't see it that way.
You think it's about killing deer?
We think it's about killing deer and using a bow. The town took the position.
Counsel, I'm sorry, I'm on the screen to your left.
Sorry.
Hi, yes, hi. Happy New Year. Is it possible that both purposes are in play? I mean, you seem to posit in response to Judge Canataro that they're mutually exclusive, and I don't understand why that's the case. It seems to me that any of these setback hunting provisions have, at some level, a concern about safety, if not safety for someone outside of the hunting area, certainly for safety about other hunters. So
Certainly,
it's possible it can have a dual purpose, yeah?
I believe so, but the ECL is still strictly focused on the safety of hunters and the accomplishment of the kill. It's
But
the-
doesn't your concession now that it is concerned about safety of hunters mean, of course, that there is, in that amendment, as Judge Canataro was asking you, there was a consideration about safety, so isn't that the case? You may think it's only about hunters, but it is not the case that it's solely about killing deer, which I think was the back and forth that you and Judge Canataro were having.
It's difficult to tackle this question on both the judges' behalfs because the record that was before the trial level court as well as the appellate division, as well as the legislative history that you've probably seen here, we didn't find any proof of any of these assertions about a bow falling before 150 feet, et cetera, or, why 150 feet would have been proven to be safer for the public. The ECL does not address when discharging any implement creates a hazard for the public. That gap was left open in the ECL. The state legislator filled it to the extent it passed Town Law 130, sub 27, and the town closed the door on it by saying, yes, we do agree with the 500 feet. It was in 2012 that we amended it to clarify that we agreed with the state's position on 500 feet. We weren't taking a position on hunting. However, most of these cases of preemption come before you when a locality has amended a code or passed a new code that conflicts with the state law. That's not what happened here. The state, for more than 50 years, had a 500-foot setback rule for both bow as well as firearm. In 2012, we were missing the 500-foot mention, so we put it in to clarify, because hunting goes on in Smithtown, but so does, archery, people who want to practice, et cetera. It wasn't strictly hunting. It was the state that made the change here. It was the state that decided to reduce the setbacks for longbow to 150 feet, and it created a new setback where crossbow is considered. Prior to then, crossbow was considered so dangerous in New York State, it wasn't going to be allowed at all. So there is a remarkable lack of proof put forward by the respondents on the appeal below in the trial level as well as the appellate division level.
Let me ask you, counsel, let's say we agree with you and you're right, that really the ECL is only about hunting and the town is only concerned about public safety. So there's obviously at some point overlap. Does that mean that at a minimum, even if we would agree with you that that the town law can only apply outside of the hunting context?
Well, we didn't want to take a position on hunting because we left that to the state. But
I understand, but I guess I'm asking, isn't that the logical, sort of, isn't that where we end up if we agreed with you? That to the extent that you're saying the state, of course, it's exclusive to them to deal with hunting and wildlife management, but that's not the purpose of what we have done. We're focused on public safety writ large. But to the extent there's that little overlap, right?
Right.
Doesn't that mean then that the town law cannot apply in the hunting context, which in part would mean wherever hunting is permitted during the hunting season?
Right.
Is that, would you
Where-
concede that that has to be the logical conclusion of seeing the laws as you have now argued them?
Our position, Judge, is that there's a conflict there, but we believe that it's not an impermissible one. We believe it is permitted because at the end of the day, state government has turned to local government and said, there's a whole host of things we would prefer local government take care of, local policing take care of, because they know the areas, they know the people. The hunting that goes on is not constrained in any way. So we have deer now that roam through neighborhoods.
Thank you, counsel. Counsel?
Hello, if it pleases the court. My name is Christian Kaloran, and I am counsel for the respondents. Your Honors, we view this case as essentially a clear-cut preemption case. We feel it's our argument that the state town law does not endow the town of Smithtown to regulate the discharge of a bow and an arrow.
So can I stop you there, over here? Can I
Yes,
stop you there
Judge.
for a second and go to a different variant of Judge Rivera's question? Suppose the ordinance here had purported to regulate, let's take an easy case, archery ranges only, and had a greater setback, 1,000-foot setback for an archery range. Is that preempted?
I would say it would be preempted.
That would be preempted as well,
Yes, I would say it would be preempted.
even if it's not for hunting. So what then, what preempts it?
Well, because it's clear at that point, the rule would be pursued under municipal home rule. But the moment municipal home rule, manifests as a conflict with state law, there is,
What would be
there's
the-
there's essentially a conflict, and
what is
that would
the-
occur in that dynamic.
What is the state law with which that would conflict?
And that would be the ECL law, because the ECL law does not confine the discharge of a bow and arrow to hunting. It simply regulates the safe discharge of a bow and arrow. It does not specifically confine the discharge of that arrow within the context of hunting. Now, I imagine that there was rationales for why that is, and it most likely had to do with practicing archery to be more effective in the field and to be more safe. That would be what I imagine was the logical reason. But to answer your question, I would say that it would still be conflicted.
Okay, thank you.
Well, Counselor, where does it say expressly in the ECL or even in the legislative history that a hunter has the right to use the bow and arrow beyond the 150 feet? Would you agree that it's not expressly said?
Beyond the 150 feet?
Yes.
Well, it sets a baseline minimum.
It
So
sets a prohibition.
It makes a prohibition that you cannot discharge the apparatus within 150 feet or below.
Right.
So I think it's implied, therefore, that you are able to shoot it over 150 feet. I think that is a,
Well, do you think that that's what our case law and our precedent is saying? That we should just rely on an implication that is not expressed? Isn't our precedent saying exactly the opposite?
no, I think the law is pretty clear that people, are, as long as they're licensed, are able to pursue the tradition of bow hunting in the state of New York, as long as they do not violate the setback restrictions, which are in New York State 150 feet of a dwelling or thereunder. I
But
think-
doesn't our case law say that just because a prohibition is set up, that doesn't mean that it's permission for other conduct? Haven't we said that in People v. Cook, in Zakrzewska? Isn't that exactly what we were saying, that that authority is too broad, that your reading is too broad?
No, I don't think and those examples would be for other conduct. I think the law is specific, again, to the discharge of a bow and arrow, and I think the ECL is clear that it is legal to discharge a bow and arrow as long as you do not violate the setback requirements.
Well, show me where it's clear. Can you point to something
Well,
that says it's clear that you can discharge your bow and arrow past 150 feet?
Judge, all I could to do on that front would be to point to the ECL at large that regulates the management of wildlife in the state of New York, which endows New York State residents with the ability to get licenses and to pursue hunting within the state of New York.
Counsel, can I ask maybe that in a little bit of a different way? Because I think it's something, I have the same kind of concern. And if you look at our case law, there's support for this. So we would agree that if the ECL said nothing about bows and arrows, right? And this local jurisdiction did this, that would be okay, even though technically under the state law, you could discharge your bow and arrow wherever you want, right? Like, we wouldn't take that to mean, you know, the city couldn't limit it to 500 feet, let's say, if the ECL said nothing. I know it doesn't, but let's assume.
If the ECL was quiet on the subject.
Right. So I think what we have to decide is where on this line does the ECL fall in terms of your point, which is there's a negative implication here that's strong enough, looking at all of it, that anything over 150 is okay? Or is this the case of more like silence, and it's not, but that it's more analogous to silence in that you just can't take from the fact that the state hasn't said, you know, you can do this over 150. Do we read that to mean, you know, how do we read that
Well,
in terms of
I think the key point for analysis is whether or not the action permitted under the local ordinance eventually manifests in a conflict with state law. If it does not, then I would say there would be no conflict preemption. But if it does,
Right.
I would say that it does, which is clearly the case here. I mean, there's two.
But let's say, to go back to Judge Singus's point, there's a case, Vittori, I think the name is, on cigarette vending machines, right? So the state has a cigarette vending machine law that was arguably more restrictive, and I don't know what the locality was, I think it was in New York City, but that was arguably more restrictive in terms of where and when, where you could place these machines than the city law. And this court concluded that's okay. Why is this different than Vittori?
Well, if the state law was more restrictive than the local law,
No, the state said, you know, you can put them here, but it wasn't feet, but it was less restrictive. I'm sorry if I misspoke.
Okay.
The local law, in ways, in terms of placement of these cigarette vending machines, was more restrictive.
the analysis, I would imagine, would be whether or not the local law evidenced or manifest as a clear conflict.
But yeah,
That-
we
that-
all agree
that-
with that, but
yeah.
how do we figure that out?
Well, I think, if I may use the circumstances in this case, when in fact, if the local ordinance was effectuated, what once was clearly legal, which was the discharge of a firearm, as long as the 150 setbacks were honored and respected, was now made illegal. I think
But I
that.
could put my cigarette vending machine, I don't know what the rule was, but let's say I could put my cigarette vending machine next to a school, you know, under the state law, but now under the city law, I can't. Why isn't that the same analogy?
The analysis, and I'm unfamiliar with the case that you're specifically referring to, so I'm not sure what factors they considered about, I guess, the nature or the substance of the conflict, but I imagine that the court felt that it was incidental to, or not so much being in direct conflict or significantly in conflict
Counsel,
with the state law.
I'd like you to assume for a second that the rule of Vitor is not to look for a clear conflict, but rather to determine whether the local provision is consistent or not with the larger state statute.
Yes.
And if the rule is consistency, could you not argue that this rule is consistent with the ECL provision? I know that 500 and 150 are different, but the principle behind the ECL is that in order to create public safety, you need a setback. And the local consideration, as we heard from council, is that Smithtown is a densely populated suburb, so they need more of a setback than what the statute provides. I don't know if that's a conflict. I know it's not the same, but would you call that a conflict?
I would absolutely call that a conflict, because the boundaries of municipal home rule are finite, and they can only essentially lawfully be placed up until the outer parameter where there is a conflict. I think in this particular case, there is a clear conflict that would be effectuated if the local ordinance was adopted, because
And how do we know that
once-
that's not incidental?
that is not incidental
Yeah.
to public safety. And the reason that it isn't is because the state, when enacting the ECL, and I think it's contrary to the appellant's argument, took into account the safety considerations. And they went more so when they adopted the town law, because they...
No, how do we know, I'm sorry, maybe you're answering the wrong question, or I asked the wrong question. How do we know it's not incidental, an incidental degradation of what you're characterizing as the right to hunt?
Well, I think we would have to analyze the effects of the local ordinance going into place, which would entirely eviscerate the DEC's ability to effectively manage wildlife management throughout New York State, because there would be a labyrinth of Byzantine regulations that were implemented in a location like Long Island, where Smithtown is located, where there only is, by the way,
Well, what I'm
bow
struggling
hunting.
with is, I think you correctly, said that when we're discussing conflict preemption, if the impingement is only incidental, there's not a conflict. So that's the legal test we're stuck with. How do we determine in this case whether it's incidental or not incidental?
Well, I believe that the analysis falls upon whether or not the local ordinance impacts negatively upon the state law and the degree that it does. I think what might be getting lost in the analysis, at least from the appellant's paperwork, is somehow that the state did not consider the safety considerations when it reduced the setback. And I would argue to you that clearly it did. Just analyzing a setback restriction in and of itself is inherently a safety ordinance, because why would you have any discharge setback requirement at all? But if we analyze the memorandum, if we analyze the transcript and the legislative history of the 2014 reduction, you'll see that they did take into account the safety considerations. And more so, the town law incorporated the ECL. And in doing so, they incorporated the definitional distinctions between a firearm, a bow and arrow, and a crossbow. And they set different setbacks for each apparatus. So they were clearly cognizant of the safety considerations relevant to each respective apparatus.
And
Thank you,
counsel-
counsel.
I'm sorry, they set minimums, they didn't set maximums, correct? So can we really talk about a conflict if they're not saying this is the maximum? They're saying you can't discharge a bow and arrow less than 150 feet away. I don't see how another setback beyond that is in conflict. And shouldn't we ask for better policies and more explicit language if we're going to say there's a conflict?
Perhaps so. Asking for more legislative guidance, perhaps so. However, I do think it is clear that the ECL contemplates bow hunting and bow discharge beyond 150 feet.
Thank you, counsel. Counsel, your rebuttal?
First of all, if the municipal home rule law doesn't set a bright line test on these things, it actually gives local governments some incredible control over issues like public safety. Moreover, Council's describing, he's described that that everybody should have considered what the effects will be of the town's 500-foot setback. Our setback is the same 500 feet that the state used for over 50 years. So again, it wasn't the town that changed the rule here. It was the state.
But the timing of the conflict really doesn't matter, does it? I mean, a conflict's a conflict. If the state came in and decided we want a new rule, the state legislature, and they said this is the new rule going forward, and it conflicted with this localities law, then that law is a conflict now. I mean, it doesn't matter we were here first, right? That's not home rule.
Then
It's
every
conflict
time-
is the essence of home rule.
Then every time the state is going to change this rule on behalf of hunters, the town's power to protect ordinary citizens who are not involved in hunting, the general public, nearby residents of where this is going on, this is not regulated activity pursuant to areas.
But that's a different argument, right? So it's the conflict that's key, and if you're right in your portrayal of the difference in the laws, it doesn't matter what the timing is. But if the conflict is there, it likewise doesn't matter, seems to me, what the timing of the law is. Because the state has the authority to overrule a locality, even if your law's been in effect for 100 years, and they want a different statewide rule, that's a conflict now.
Then perhaps the focus should turn to what the ECL left out. And what they specifically left out was when discharging anything for any purpose is hazardous to the general public or nearby residents. We
But is
filled
the
that.
label really, so how far could we go with labeling? So if there's clearly kind of a dual purpose here, and you say, yes, hunting, but the reason for the discharge rules in hunting is safety, as I think Judge Rivera was pointing out. So if the town law now labeled this as well-being, healthfulness, it's a different statute. It's aimed at something else. It's aimed at happiness. Then you could get out of any conflict by just labeling it something else. And it seems to me the real issue, and I'm not saying which way this cuts at the end of the day in terms of conflict, I think you've both made very good points, but is what's the substance of this law? What was the intent of the legislature? And does that conflict with what the local jurisdiction has done here?
I fully agree with you, Judge, that at the end of the day, you're charged with looking at the intent of what the legislature wanted to accomplish here. And our position is the legislature, through ECL, accomplished 99% of what it did was in favor of hunting for wildlife management purposes. That is its stated, explicit, expressed purpose as it was written. Nothing in the declaratory provision of ECL says anything about public safety. I believe that's why town law was...
I'm asking this because I'm not sure, but in the ECL, is it discharge is restricted near what? Near other hunters or near other
It
facilities?
doesn't say. It only puts these provisions on...
So it's 150 feet from what?
I believe they have identified a series of locations, like a dwelling, a park, an occupied building.
So I don't see how that only applies to hunting and not public safety, because you don't want people shooting arrows in the forest that are going to go into a school, I guess is the kind of impetus behind some of that.
Exactly, and that's why we did the same thing under town law.
So
We
that gets the-
identified locations very similar.
Right. Isn't that not a great point, though?
I guess it depends on which one you want. Which intent is more important here? Killing wildlife as a management issue, or
But
is
I
it
don't see how
protecting people who
discharging a
live...
bow and arrow near a school has anything to do with killing wildlife. Like, what you're trying to protect are the people on
Are
the
the
other side
people.
of the wall.
I mean, at a very
But-
simplistic level, the legislature gave you the ability for firearms to go, to diverge, to set a higher setback, and didn't for bows. And how do you account for that?
We account for that in a couple of ways, Judge. First off, there was no definition identified under Town Law 130, sub 27. There was no definition in the body of a firearm in ECL. you have to look to their regs at 6 NYCRR 180.3 for a definition of firearm. However,
But the town can't define a banana as a firearm, right?
no, it can't, and that's why I agree with you. From a technical standpoint, Judge, a firearm, as we know commonplace, is a gun, a pistol, a rifle, etc. And a bow is a bow, as we know, is a bow and arrow or crossbow. However, if we don't include them as a grouping, which both the state and the town did, when you look at their provision, their title is about possession, prohibitions against the use and possession of firearms. Yet under those, they have categories, and they include bow, longbow, and crossbow with their categories right alongside with firearms.
You're saying 6 NYCRR 160 defines longbows as firearms?
No, sir. The state regulation for ECL only defines a firearm. However, it only allows it to be applied for Title 11, Article 11 of the ECL, which is the wildlife management provision. So,
But there are other statutory definitions of firearms that also do not include longbows. As a matter of fact, I think you conceded in your brief, there is no statutory definition of firearm that includes longbows. Is that correct?
not to our knowledge, there isn't, Judge. However, if we don't expand the concept of firearm to include bow, we will have destroyed the purpose of Town Law 13027, together with the ability of our local police to protect citizens.
But
from
counsel,
this
see that,
activity.
counsel, if I may, that's my issue. It does seem that this boils down to, the state has made a determination about what setback still allows for safety, and the town thinks that that's wrong,
Correct.
right? And as a consequence, you don't permit what the state has decided is safe, because you just don't think it's safe. And that is the bottom line question, which is pretty hard to get around, that is just a conflict.
Judge, this is probably not the first time in history that we've had a conflict here, but it's not the type of head-on collision where we're saying you can't hunt in Smithtown. We haven't done that.
Well, you don't need, a conflict doesn't require out-and-out prohibition, absolute prohibition, right? I mean, that was in
No.
part my other point about the overlap.
Right, the overlap. We consider the overlap a reasonable exercise of our power to protect our citizens. It's viewed, some people could use the word incidental to describe it. The state has not proven that shooting a bow at 500 feet is interfering in any way with the purpose of the ECL and wildlife management. It's not required uniformity across the state. The state is very different from the north regions, the south regions, Long Island, the Mid-Hudson Valley. These are all very, very different communities with different density population problems.
Counsel, just one last thing, and I know we're out of time, but this case, unlike some others we've had, the state agency has weighed in here saying that it is preempted. How much deference are they entitled to?
As a person representing the town, I would say,
How about a person representing the town within the strictures of our case law?
I would say the deference up until the point where they're wrong and they're violating state law that authorized us to do what we did.
Thank you, counsel.
Thank you. Thank you for taking the case.